Sarah Phillips with Phillips Law, a criminal defense firm based out of New Orleans, Louisiana. If you've been charged with a crime, one of the most powerful tools your lawyer may use is something called a motion to suppress. And you may be thinking, okay, but that's all great and everything, but what the heck does that actually mean? So let me explain it in plain English. So what is a motion to suppress? A motion to suppress is a formal request asking the judge to throw out certain evidence because it was gathered illegally, unfairly, or in a way that violated your rights. So if that motion is granted and the judge says that evidence was illegally obtained, that evidence can't be used at trial. And if the DA was relying on that evidence to prove the case, it can become a game changer. Sometimes it leads to the charges being dropped altogether, which is amazing for you. So when would we file a motion to suppress? We usually file a motion to suppress after we've had a chance to look at all the discovery, which is the evidence the DA has turned over. If we see something that looks like it was illegally obtained or improperly brought before the court, we start digging. So here are some common situations where a motion hearing to suppress might come into play. So illegal traffic stops. If the police didn't have a valid reason to pull you over in the first place. We look at bad searches. If the police searched your car, home, or your pockets without a warrant or a probable cause. Any Miranda violations, if they questioned you without reading you your rights. We look at coerced statements, whether you were pressured, intimidated, or maybe even tricked into saying something. Bottom line, if your rights were violated and evidence came from that, we ask the judge to suppress it to keep it out of court. So what happens at a motion to suppress hearing? So this is a special kind of court date where the judge hears both arguments from both sides, the district attorney and your criminal defense attorney, about whether the evidence should be thrown out. So if we're the ones filing the motion to suppress, so we'll call key people like police officers, witnesses, and ask them about what happened. The DA will then have a chance to respond and ask their own questions too. At the end, both sides will make their arguments and the judge is going to decide, does the evidence stay in or does it get thrown out? Now, why does this matter so much? Because sometimes your entire case is built around one piece of evidence. For instance, let's say the DA's case is based on drugs found in your car, but the officer didn't have a valid reason to stop you in the first place. If the judge agrees and throws out that evidence, the DA may not be able to move forward at all. So in that one motion hearing, it could lead to the case being dismissed entirely. So that's really why these motions to suppress are really important. A lot of people want to know, will I have to testify at a motion to suppress hearing? Most of the time, no. We don't usually put our clients on the stand at this stage. Even if you feel confident speaking, going under oath can be stressful and it opens up the door for cross-examinations. And more importantly, if you testify later, such as at a trial, the DA could try to use anything you said earlier to challenge your credibility, even if you're just slightly inconsistent. That's called impeachment, and it's something we try to avoid. So unless there's a good reason for you to testify, we will handle the hearing ourselves. That's part of how we protect you and your case. So what should you take away from this? A motion to suppress isn't just a legal formality, it's a strategic move. It's how we hold the state accountable, it's how we challenge bad police work, and sometimes it's how we win the case before it ever gets to trial. So if you've got a motion to suppress coming up, know this, it's a big deal, and your lawyer is using one of the strongest tools in the toolbox to fight for you. If you are a current client of ours and you have questions about your upcoming motion to suppress hearing, as always, give us a call. Write us on Clio. We are always here to answer your questions and we are happy to walk you through it. If you're not yet a client, but you are facing charges in Southeast Louisiana and thinking, I want a lawyer who explains stuff like this, then give us a call. Our number is 504-395-8867. We'll talk with you for free and let you know how we can help. So thanks so much for watching, and be sure to check out the rest of our videos if you want to learn more about how the criminal process works. Thanks so much.